Welcome to Constangy Clips, the series with tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Cara Crotty, and I'm an attorney in the firm's Columbia, South Carolina office. Today, I'm going to talk about pregnancy accommodations and what employers should be doing now to comply with federal law. Over the years, a number of states have enacted laws that require employers to make reasonable accommodation for pregnancy and related conditions. Then, in 2023, the Pregnant Workers Fairness Act took effect. This federal law requires employers with 15 or more employees to provide reasonable accommodations for known limitations related to pregnancy, childbirth, and related medical conditions. Here are 4 practical considerations for employers seeking to ensure that they are complying with the law. First, generally treat pregnancy accommodation requests similar to disability accommodation requests, but not exactly the same. Many pregnancy accommodations are often simple and temporary, such as providing a later starting time for an employee experiencing morning sickness, more frequent restroom and water breaks, or allowing an employee to work from a seated position. These accommodations can normally be provided upon request. In this respect, pregnancy accommodations may require more of employers than disability accommodations under the Americans with Disabilities Act. If the pregnancy accommodation request is more involved, the employer should engage in the interactive process with the pregnant employee and try to work out an accommodation that will meet the employee's needs while not causing undue hardship for the employer or coworkers. As always, documenting the conversation and the accommodation is still important. Second, provide training for managers. Supervisors and managers are often the first people employees approach when they need help. For example, an employee might tell her supervisor that her doctor told her not to lift heavy boxes during pregnancy. That statement is likely to trigger an accommodation request, even though the employee never uses the word accommodation. Supervisors and managers should be aware that pregnancy accommodation is legally required, and if they believe that they may have to deny a request, they should immediately refer it to HR. On the other hand, if they are able to immediately grant the request, they can do that, but they should still notify HR of the action taken. Third, don't be too fast to go with the leave option. Under the Pregnant Workers Fairness Act, an employer must provide a reasonable accommodation unless providing it would be an undue hardship. That is a demanding standard. The Act also prohibits employers from requiring a pregnant employee to accept more restrictions than necessary. In particular, an employer generally cannot force a pregnant employee to take leave if the employee wants to continue working and if another reasonable accommodation would allow her to do so. For example, if a warehouse employee has a temporary lifting restriction, rather than placing that employee on leave, the employer may consider light duty or a short-term reassignment of heavier tasks. Or if an employee needs to sit periodically, providing a stool or a chair may allow her to continue working safely. On the other hand, if the employee prefers to go on leave, then it is fine for the employer to allow it, but the employer should ensure it has documentation that a leave is the employee's preference. Explore all potential opportunities before requiring a pregnant worker to go on leave. Finally, when considering pregnancy accommodations, be sure to keep other employment laws in mind. In addition to the Pregnant Workers Fairness Act, employers should be sure that they're complying with other applicable laws, which could include the ADA, the Family and Medical Leave Act, state laws that require pregnancy or disability accommodation, and state paid leave laws. For example, a pregnancy with complications could qualify as a serious health condition under the FMLA or a disability under the ADA. Employers should ensure their HR teams understand how these protections can work together. The key takeaway is that pregnancy accommodation requests should be handled promptly and consistently. Updating policies, training supervisors and managers, and documenting decisions are excellent steps. If a requested accommodation can't be granted on the spot, employers should engage in the interactive process, just as they would with a disability accommodation request. Taking these measures can help employers stay compliant while supporting employees during pregnancy. Thank you for watching. Be sure to follow Constangy on LinkedIn Facebook, and YouTube for important updates and more tips for minimizing legal risks.